I just want to thank you all for coming over here. This is a great segue for the topic that we just left. When you heard from the Office of the Attorney General, they mentioned fiduciary duties and corporate governance. What we're going to do today is we are going to hone into a particular aspect of that corporate governance, being your organization's bylaws. Now, something I would like to do, because I want to make sure, because of the nature of the title, that I'm clear about what this is and what this isn't. To start, this is not legal advice. This is just suggestions based on my experience. I recommend that if you are a current client or you would like to be a prospective client, we have a conversation after this is over. However, I do recommend and would love anyone to ask questions. So if you have a question, raise your hand, because I'm of the belief if you have a question, your neighbor probably does too, and we can both learn something. So please go ahead and ask questions. Now, an annual review is not an amendment. I am not saying, do not say I said, that you should be amending your bylaws every year. Because the truth is, you shouldn't be. But you should be reviewing them annually, and there should be things that you should be aware of. Also, and this will come up in other parts of this discussion, many of you will be joining boards. And when you join a board, this is the things that you should be looking through your corporate documents, your bylaws of the organization that you're joining the board of, to understand. So this is why I focused it on annual, because this is really anytime you join a board and regularly, annually, going through to make sure you understand. Because even someone like me, who loves this, talking about bylaws is why I get up in the morning. You may think that's lame, but I think it's very, very fun. Even I cannot remember everything that's in everyone's bylaws all the time. So it is good as an exercise to go through these documents to remind yourself of the things that you should care about. I will say that a lot of these regulations are about perfect process making you perfect. And by going through the steps, going through the motions, it helps protect you from yourself. Earlier, the Attorney General said, we are not the boogeyman. That is true, but the regulations are not your enemy. They are your friend, because they're here to make sure that you do right by yourself and by the organization that you're representing. So I highly, highly recommend that you go through this, because when I get on the phone with clients go, well, I don't want to do that. But usually there's reasons for these rules, and they might be annoying, they might be tedious, but as some of you may have heard before, the devil is in the details. So let's do our best to diminish him. All right, so bylaws. Does anyone know what bylaws are? Yes, ma'am.
Oh. Okay. I will answer based on my understanding of what bylaws are. Bylaws are the system of rules, regulations that govern the functioning of your organization that have created the standards by which you function and operate. And you have registered with your Attorney General's office of the state or Consumer Affairs, and that you will be accountable to functioning based on these rules. Was that long and drawn out?
I should sit down. You're going to give this presentation now, right? What she said was that the bylaws are the rules and regulations for your organization. And that's what it is. The bylaws are, this is how we run, and this is how we run it. That's what it is. It's just simple rules. It's how the game is played. What's the game? The game is corporate governance. Now, you should be aware, there are some rules that are in your bylaws. Now, there are other rules that may not be in your bylaws, but still affect the game. So, the World Series is still going on. At least that's what I was told. And what? Go Yankees.
Yeah.
Go Yankees. The World Series is still going on. So let's use a baseball metaphor. There are the rules of baseball, right? And that's your bylaws. But there are certain rules that affect baseball that we still have to care about. Physics, for example. The equivalent of physics in this situation is New York state law. And as you heard the Attorney General say before in the previous session, that is the not-for-profit corporations law and the religious corporations law. Now, they focus, and a lot of us focus as practitioners, as lawyers, on the not-for-profit corporations law, because it is what I would say well drafted. The religious corporations law is what I would say poorly drafted, with carve-outs for the carve-outs. Specifically, and this is what is especially important for religious organizations, with special carve-outs and special rules based on the denomination that you are. In New York State, the religion that you practice quite literally changes the way your organization has to function. And that is partly to respect the deep spiritual and organizational traditions of your faith, but also because it's written that way. Now, people may ask, what did my denomination do to be one of the special denominations? There are sort of two reasons. One of them is your organization is incredibly hierarchical, and it did a great job of making sure its special circumstances were incorporated within the religious corporations law. The second, and I think this is more pragmatic, is your organization was around the time of 1910, which is when the religious corporations law was largely passed, and they had better lobbyists. So now, in 2024, we have to abide by those rules and regulations. Now, something that you will even see, because these were codified so long ago, is that your religion has changed and evolved, and the way of corporate governance as understood by your religion has changed, but the religious corporations law has not. So a huge aspect of what you do when you work on religious corporations bylaws is balancing, this is how my faith tells me I should run my organization, and this is how the law says I have to run it. And those things sometimes work together and sometimes are at odds with each other. The biggest fundamental principle I see that at odds is who runs the organization. Is it the board of trustees of your organization, or is it the spiritual leaders? And what happens when those two people are the same, or groups of people are the same? All of that are things that you're going to have to think of when you're reviewing your bylaws. Because then you're going to be like, well, Will, you said we weren't talking about amendments. But a part of this review is figuring out what needs to be amended, right? And you may not be doing the amendment annually. You should be doing amendments when they're necessary, which for most organizations is every 5 years. But you should be keeping an awareness of what's going on and what needs to be updated. And like the Attorney General says, most organizations' bylaws are out of date. They're out of date because they have not been looked at and updated. One of the questions that I start every consultation about when we do corporate governance is, this is what your document says, now tell me how you actually run. Because 9 times out of 9 times, not 10, they are not the same. They go, we don't follow that anymore. It just doesn't work. And the thing that is a real thing is a lot of churches are losing membership, and they go, we just don't have the size to be this big anymore. And that's fine. But what we have to do, and the importance of the annual review, is to update your bylaws to make them make sense for the size of the organization. So that is bylaws. We're going to go through some of those key areas that you should be aware of. So, membership. What is the membership of a religious corporation? Anyone want to take a guess as to what this is? Parishioners. Now, as someone who's gone to church, there are 2 types of parishioners. There are members, and there are the people who show up on Sunday. And they are different. I do not walk through the church doors and all of a sudden I become a member of this church. That is not what I'm saying. That is often a concern of a lot of religious corporations that I represent, that someone's going to show up and they're a member and all of a sudden they got to get voted to the meeting. No. Service, worship is a service that you provide to the community. Showing up to the service is not what makes you a member. Now, I'll say the Religious Corporations Law does establish qualifications for membership. All of them typically require attending worship regularly as a requirement for membership. So it is what we call necessary, but not sufficient. So membership is people who show up to church. What else? Who said tithing? The thing that people, like, pastors don't love to talk about tithing, but I'll talk about tithing today. Tithing. Typically, there's a requirement, and this is usually specifically said in the Religious Corporations Law, that you need to tithe in order to be a member of the organization. Now, the Religious Corporations Law makes adjustments for this. For synagogues, for example, it's membership fees. And sometimes for the general catch-all section of the Religious Corporations Law, what they'll use instead of the word tithe is they'll say regularly contribute, right? But this is a through line throughout the entire Religious Corporations Law, is that you are showing up and making financial contributions. What is the third thing that is typically the requirement for membership?
Age.
Accepting being presented to the congregation as accepting membership.
Exactly. What this is, though, because this is different for every denomination, yes, so what it is being accepted by the faith, right? Sometimes this is baptism, sometimes this is being like confirmed by the congregation. It is some sort of ritual, spiritual requirement, in addition to the secular requirements of you're showing up and you're paying money. Right? And now because the paying money part of this is where New York law really starts to focus in. Because these people are how you have money. They are the people who donated to this organization. And so in this way, New York law treats them akin to shareholders. Now, I had a client this week go, well, if they're shareholders, does that mean they're going to get dividends? No, you are not getting money by joining a church. I can tell you that right now. If any of you walk away from this, well, but that's not because that's between you and Jesus. That's not between me, or it's between you and your spiritual leader. No, come on now. So you are not going to get money like a shareholder will, but you are treated as someone who is invested in this organization, and you are the people that the organization is looking to in the same way that shareholders are. Like, for instance, you may have heard of the standard that you sometimes hear when you talk about businesses, is what's in the best interest of the shareholder. That exists in the Religious Corporations Law and the Not-for-Profit Corporations Law. It is what is the best interest of the members. And that is why I say they are like shareholders. So those three things are how you are a member. Now, this is where the annual review comes in. Because for membership, you should be reviewing what actually defines someone as members. But that's great that you have this esoteric, well-defined definition in your bylaws that you're reviewing and making sure it's consistent. However, that is only half of it. Because just because you have them well-defined in your bylaws, that's not all. You have to know who those people are in practice. You're required, as a part of the Not-for-Profit Corporations Law, to have a list of these people. And if I show up, or the Attorney General shows up, and I say, show me this list, you have to be able to provide it. So this is only half of the job. The other half is, exactly like the Attorney General said in there, is good record keeping. So both of these things, y'all, we're just on the first bullet. Don't you love this? Who are they, right? Now, the other things for membership is you have to think about quorum, which is when you have your annual meeting. How many people must be there in order to say this is a valid constituted meeting? A lot of times quorum will be based on the total numbers of membership. Again, this is why it's important to have that list of members. You have, without that list of members, without knowing there are 100 people, how do you know what 50% is? You have to be able to do that, right? This is how that first concept bleeds through all of this. Voting thresholds, you have to know what they are. How many votes do I need for this to pass? When are membership votes required? Now, the Attorney General of the state of New York takes the position that a membership vote is always required. What this means is, because you're like, what? Is if you do something, the members have to vote. Now, there may be limited things that the Board of Trustees are empowered to do without the membership. But what that does not mean, though, and this is where I very often have communications with clients and they go, well, we don't ever do that, and this is something that you should change, is if you have members and you are transferring real property or getting into an agreement for real property, as an example, this is a very common one, you'll have something in the bylaws that say the Board of Trustees is responsible for the property, and because of that, you don't have the members vote. Unfortunately, in New York, I'm going to tell you that is not okay. The members have to vote if you encumber the property in any way. And this is, think about this, because let's say it's a simple use agreement. The Board of Trustees enters into it, and God forbid, someone fell. That person sues you because they fell on your property. And now there's a lien on your property. And now, because of that lien, and you're unable to pay it, that lien gets foreclosed on the property. And because of this one little agreement that the members didn't approve, you're now in a much more complicated situation. Now, that's on the margins. This is me rattling my sabers, talking about the broccoli horrible. But that's what the law protects against. And this is why it's actually in your best interest. You know how many times I have a pastor on the phone and they go, well, we just don't want to deal with the members. It's just so much work. We'll have the board vote. It'll be fine. Everything's up. But this is why you have to do it. You have to do these things when membership votes are required. How are meetings conducted and noticed? This is important because when you think of a meeting notice, what most people think is, I'm going to put something in the mail, and it's going to go to all the members, or I'm going to email all the members. For most religious corporations, you actually have notice easy because, and this is why a part of membership is attending service, is the way most meetings are noticed. Again, we can talk about how it is for your particular organization, but it's actually an announcement from the pulpit. And I will say, as someone who deals with business people, as someone who represents religious corporations, it takes a long time to call a meeting of the church because traditionally you have to announce it for 2 Sundays before that meeting can happen. And when I explain to the business world that it's going to be a minimum of 10 days before I can get something signed, they're never pleased, but that's just a part of it, right? Good governance takes time. Perfect process makes us perfect. Any questions about membership before we move on? Yes, ma'am.
So, going back to the real property
Yeah.
example, many of our churches now are getting smaller. Is there a minimum number of people that you need to have that represents a corporate body? Like in my case, maybe there's only 4 or 5 of us left.
And we're congregations, just.
Yes.
Yeah, so this is actually really interesting. So in order to form I start to get concerned, right, when an organization has less than 6. Because when you have less than 6 people, that's actually less people than you need to incorporate. In order to incorporate a church in New York as a formal legal organization, you need 6 for most types of religious corporations. So when you start to have less than 6, you have a problem. The magic number for board is your board must be at least 3 people. So basically, anywhere between 3, anything below 6, we could figure something out for 3. But once you hit below 6, I start pressing the red button about let's have conversations here. Yeah, that's actually the dissolution process, which is the next session. Stay right here. You're in your right spot. It's in this room. Yes, ma'am. Sir.
Is there like a dollar amount that you can put into your bylaws, your constitution, that the board can act on behalf of the wider congregation?
That's actually a recommendation I would make. If you have a membership for a religious corporation, if you want to have a dollar amount, because when you do something like that, I would make sure to belt and suspenders that. My recommendation would make that, my recommendation, just that I'm saying to no one in particular, because this is not legal advice, is that be a part of a bylaws revision that's approved by the members. We'll talk about amendments later, because essentially what's happening is when the members are voting on the board of directors, and we'll talk about how members should be doing that, is you're essentially vesting them with the power to do that. So the members are delegating their authority back to the board. But I will say, in some situations, even that delegation is overridden by New York state law.
But real assets would be the entire.
Correct. Yeah. So there are some, because again, the thing is, this is always,
Case by case.
it's the eye of a needle, right? It's the eye of a needle, what we always have to get through. So that's membership. Yes, ma'am.
In terms of meetings where votes are taken,
Yes, ma'am.
can you vote online?
That is a huge thing that is recently, and I will actually say, you actually can thank Mr. Joe Milano, who's in the back of the room, who wrote an article that had this changed. But religious corporations are allowed to have electronic meetings. And thanks to Mr. Joe Milano, they're actually, in his efforts to write about this topic, which actually inspired some legislative action, actually allows religious corporations to have hybrid meetings. They used to not be able to have meetings. And so through my understanding is Joe actually illuminated that issue, and it actually caused some people to Congress people. And so everyone say thank you to Joe every time you have hybrid meeting. But what that means is you're allowed to have an electronic meeting where some people show up to the church or the house of worship, whatever, or someone else's home, joined by Zoom, and then other people are also joining electronically. So you are now allowed to have electronic hybrid meetings in the state of New York. I will say, as someone who is frequently tasked with advising the board of trustees, and particularly the secretary of the corporation who's responsible for this process, how to conduct these meetings, my advice would to still have everyone on their own device, because counting votes for hybrid meetings can be a pain. But yes, hybrid meetings are allowed, unless you have specific prohibitions in your bylaws, which is why conducting an annual review is important, because you're going to want to make sure that your bylaws are up to date with New York state law. Because even though the law permits them, what the law says is, except if you have contrary to your bylaws, and your bylaws may say, well, no, you actually can't meet. And then, unfortunately, even though New York state doesn't care, your bylaws have bound your hands and prevented you from meeting electronically. Because you did an amendment, which is why we're all going to do an annual review from here on out. So the Board of Trustees. I did this order for a reason, because I did membership first. Because they are the keepers of the keys. They're the ones who matter. The Board of Trustees are members, typically, that have been delegated for authority because it's hard to get the members to meet. That's the reality. No one's saying that it's not. And so the way I like to think about it is, many of you may have, and we'll talk about committees later on, is you think about an executive committee, which is there for when the Board of Trustees can't meet. I like to think about the Board of Trustees as the executive committee for the membership, because they're there for when the membership can't really meet. That is why they exist. Now, something that comes up very often when I work with religious corporations, for better or for worse, the religious corporations law, in most cases, requires what's called classified board of directors. Does anyone know what a classified board of directors is? So the easiest way, my classic example, is it's like the United States Senate, which means not all of the board is up for re-election at the same time. A third. Right? That is actually what the United States Senate is. That is actually what most religious corporations are required to have. Most religious corporations are supposed to have a board composition of a number of 3, with every year a third of them expiring with terms of 3 years. I will tell you, raise your hands if you're on a board with that structure. That's more than I thought. Good for y'all. But most boards don't have that structure. It's the most common issue that I check for. It's the first place I go because so many people do not organize their board like that. And even if it's in their bylaws, they're not doing it because it is, again, very difficult to do that record keeping, to figure out who's up for re-election and when. And it just falls off and they just do annual terms. But that serves a purpose, especially for an organization like a church, which is typically volunteer run, of keeping institutional knowledge available. And so the people who know what's going on don't always just get voted out, right? It's honestly to just I personally very much like classified boards. I recommend them to any client when they're forming a new corporation because I think it has a lot of help. And so religious corporations law does us a favor by mandating in that aspect. I will say something here that I actually missed that is actually an important concept is there's actually another corporate document that really has interplay here. So there's your bylaws, but there's also your certificate of incorporation. And your certificate of incorporation is what constitutes. So in that way, in New York, you're not supposed to have, well, you can, but in New York State, you don't really have constitutions. That role is filled by your certificate of incorporation, and then you have the supplemental bylaws. But your certificate of incorporation is what forms the corporation. And oftentimes, because you have to put the initial board of trustees in the certificate of incorporation and their home addresses, you actually create a structure for the board of trustees, which you are bound by, and you have to do an amendment to your certificate of incorporation in order to effectuate that change. So in addition to making sure that your board composition is good on the bylaws front, good on the religious corporations law front, you also have to make sure that it's good on the certificate of incorporation front. Typically what I see is that the certificate of incorporation is in compliance with the religious corporations law, but the bylaws, because the bylaws typically are more recent than the certificate of incorporation, your practice has gone from what was set forth there. And oftentimes what will happen, because it's a minimum, is the minimum amount of trustees you're supposed to have is 3. So what people do is they only have 3. But the way it's drafted makes it always 3. Not just initially 3. 3 tomorrow, today, the day after. And their bylaws are unable to change it because bylaws, in the same way that Congress can pass a law, but if Congress passes a law, the Constitution says no, well, the Constitution wins. Think of it like that. Certificate of incorporation says no, doesn't matter what's in your bylaws, certificate of incorporation governs. So that's another vector of this to come through. Just like for membership, there's quorum and voting requirements that you should make sure are consistent, good, attainable, and that you're making sure that the voting requirements are being met. Also, sometimes what I always see is that there are sometimes required under law, but also by your bylaws, supermajorities. So you want to make sure that you are reaching supermajorities when necessary, or that when you're doing your annual review, if you still want to be doing supermajorities. Sometimes that may not make sense for your organization, so that's something that you should consider when you're going through to make sure you're complying, or maybe it's something you want to change. Yeah?
This may be in the weeds, but if we wanted to vote for board membership or the composition of the board, if we wanted to change our bylaws, and then we would also perhaps have to change our certificate of incorporation, is there some special process of changing the certificate of incorporation that's separate and apart from the process for changing the bylaws?
There is a special process. It's a different document with different requirements. And the difference between your bylaws and the certificate of incorporation is while New York State has regulations for your bylaws, the certificate of incorporation is filed with the state.
So we have to make that filing with the state.
Yes.
So most churches actually don't have to file with the state for corporations. They're some is Nassau County, and out in Suffolk, it's towns.
I was using state as in New York, not the State Department of New York. Yes, you're exactly right. So religious corporations actually have the option. They are still permitted to file with the Department of State. But you're right. The instrumentality of the New York State that they file with is the county clerk traditionally. but they do not file with the Department of State. This actually comes up. This is actually a blessing and a curse. The blessing is the Department of State is horrible to deal with sometimes. The curse is because they're horrible to deal with, they make sure things are done correctly. And sometimes I get documents back from the county that weren't actually in compliance with the regulations because the county's just, depending on the county, they're just accepting whatever. But yes, that's a very good point, that if you're looking for your certificate of incorporation to check all these things, you're not going to be able to find it online at the Department of State. You're actually going to have to go to the county where your principal place of worship is. I will say for New York, this is especially a problem because if you are in Upper Manhattan or the Bronx, the line between those two things always changes. And so you may be a corporation that you thought you were in the Bronx or actually you're in Manhattan and vice versa. Yes.
So can I just go back to one thing?
Yeah, of course.
I know we spoke about the membership in terms of what we recently had to do with the councils, city councils, and so forth. Are religious corporations subject to the open meeting law in terms of what we're talking with the hybrid meetings? And as well as voting with the number of membership being present. So open meeting law.
So we can talk about whether or not that applies, but traditionally when you talk about the open meeting law, that's about the government making sure that the meetings are open to the public, right? That's not really the situation that we're talking about. Now, what this comes up in the religious corporations concept is I have boards all the time, and I'm not insinuating anything because there's good and valid reasons for why they do it, but they're like, we don't want to send the minutes to the board meeting. We don't want to make our minutes publicly available, or at least make them available to the members of. You absolutely, the minutes of the board are very much, if a member said, I would like to see the minutes of the board, you should be making those available. Best practices is you should be making those available. If a member has questions about the running of the Board of Trustees, you absolutely cannot deny them access to that information. You also cannot deny a member access to the membership list, as I mentioned before, and also the financial records of the organization. I will say this is also why it's very, very important to define who your members are, especially in the religious concept, because you might be making your information more public than you want it to be. Now, the other thing that's important about the Board of Trustees is they have to be elected by the members. That is the quintessential and most important thing that the members do. It is the one corporate function that I consider sacred when I'm advising organizations, is the members, if they do one thing all year, they're voting for the Board of Trustees. This sometimes causes problems because, for instance, the Board of Trustees could be selected by your Board of Deacons, which is a thing that I know happens very often. That causes problems under the religious corporations law for various reasons. So if that is the situation that you're in, I recommend that you talk to legal counsel about how to iron that out. But that's a very common way that you see religious philosophy pushing up against New York state law. That's the Board of Trustees. Yes, ma'am.
Circle back to the whole board of trustees because, PCUSA years ago did away with trustees. So to them, that's the session. And in most congregational churches, no trustees anymore. There are executive councils. So is that the same thing? Is that equal?
So that's a really great point. So if you are a part of one of the larger denominations and this is important, that has, for instance, like a book of order or a book of discipline or something like that, you now have to have a lawyer who is both familiar with the ecclesiastical governance of your organization and then also New York state law. Because oftentimes, for that exact reason, they don't play nice. They don't play nice. And so a huge exercise of something that our office does is we have to go through, and we're good at this because at this point we've had to do this so often, is we have to go through the religious ecclesial doctrine and figure out who actually are the Board of Trustees. Because you're exactly right. They may not be called Board of Trustees. In fact, there may be a part of the organization called Board of Trustees that aren't actually what the law considers the Board of Trustees, and that's when it's really fun. Yes, it's a very complicated thing, and this is why it's important to have a lawyer who is familiar with not only the not-for-profit corporations law, the religious corporations law, but ecclesial law in general.
I hear director, like, who do you work for?
So yeah, my name is William McManus. I don't think I ever did that, actually. So thank you, a great point. My name is William McManus. I work for Capell, Barnett, Matalon, and Schoenfeld, the lawyers that are hosting this event. My particular practice area is I focus on this aspect. I do regulatory work for the firm. So I focus on aspects of not-for-profit and charitable regulation. So I'm the person who sort of does ecclesial regulation, not-for-profit law regulation in the state of New York, both religious and not-for-profit. And I also work with the IRS as far as like the regulations surrounding these organizations as charities, because as a church, are also a charity. If you want my card, you can go ahead at the front. So yeah, so that's the board of directors. Often, as another point, sometimes the religious corporations law refers to it as the board of trustees, but board of directors is the not-for-profit corporations law term. They mean the same thing. But I will say what's important and what I like about the use of the board of trustees is you may have noticed in the Attorney General's office is that the estates, powers, and trust law applies to these organizations. And that's why I actually like the word trustee, because it is a reminder that as a member of the board of directors, you are actually a trustee, which has a meaning and indicates and implies your fiduciary obligations to the organization. All right, so that's the board of directors. These are the things that you should be taking into account when you're going through this of your organization's bylaws. Officers. This one's easy. I think it's the simplest, but you must have a president and a secretary. They do not have to be called president or secretary. Just someone has to be the executive and someone has to be responsible for the corporate records. The big thing, they cannot be the same person, because the secretary is a check on the president and the president is a check on the secretary.
Is that national or just New York?
That is New York state law. Everything I'm talking about, unless we talk about a specific IRS regulation, we're all talking about New York state law in this moment.
And the penalty, if that was not honored.
That is a really good question. So this actually, if you want, we can talk about this at the end, but let's talk about it now, right? So under the not-for-profit corporations law in the state of New York and under the IRS's regulations, you have something called the board of the duty of loyalty, the duty of care, and the duty of obedience. Any violations of that is personal liability to you as the person who is doing it. Also, it's obligations of the people on the board with you. So it's personal liability for the board of directors in that way, because it is a violation of your duty of loyalty to break these rules because you're not being loyal to the organization. It's a violation of the duty of care for the other members of the board to allow that to happen. And the penalty in that is up to the Attorney General of the state of New York to determine between what happens, because part of any law is the damages, right? In the sense of, depends on what actually comes out as a result of that. But that is against the law and the Attorney General has the power to enforce it. Sometimes the most often remedy that I've seen is when these things are violated, what the Attorney General will do is they'll take over the organization, reconstitute the board, and the members of the board maybe actually be prohibited from serving on boards in the future. But if there's something untoward that happens, you may have scenarios like the Attorney General spoke about in the examples that they gave, where these people are personally responsible to make restitution for the charitable assets that were given to them that weren't commensurate with the services rendered. I want to be clear. This is most of those situations. There may be some liability on the organization. We'll talk about this, but a lot of that is liability on the individual. That's personal liability on the person who is serving on the board.
And the insurance coverage, how do you think that would come down?
So that depends on your policy. I will say that in the state of New York, there is a mandatory indemnity about people when they're discharging their duties as a member of the board of directors. However, I will say that it is considered never a part of your duty if you're found to be in violation of the duties of care or loyalty or obedience. So it's a sort of a catch-22 in that situation. So if you're acting in good faith and in accordance with your fiduciary obligations, you're going to have mandatory indemnity that's provided by the law. And also you'll be covered by your directors and officers liability insurance, which we'll talk about later, which every organization that if you're on a board, you should have. I would not serve on a board if you did not have D&O insurance for the organization. But in the same way that the indemnity will not cover acts beyond the scopes of the duties, usually insurance companies will also not support those claims. But that, again, is a private negotiation between you and the insurance company.
Would they cover conversion
What do you mean?
Embezzlement.
Embezzlement, it depends on the policy, but traditionally, depends, right? With embezzlement, what may happen is if it's specific, sometimes it's a specific rider, but oftentimes what happens is you might have, because embezzlement's a little bit different because D&O insurance is about covering it's really coverage for the individuals on the organization. Embezzlement is a separate part of that in the sense of you're making insuring the corporation in that. So again, that's a part of getting the suite of insurance. Traditionally, we talk about directors and officers insurance. Sometimes these things get paired together, depending on the insurance that you're working with, is that we're talking about protecting the individual directors. But embezzlement is a very common thing, and you should make sure that your policy covers embezzlement. Or that you get the sufficient rider to do it. Officers, you have to have a president and a secretary. They do not have to necessarily be members of the board. They can. You really have a lot of flexibility in that regard. Most boards that I work with, and what I always do if I have to make an organization from scratch, is that the president and the secretary are voted from within the board of trustees themselves. However, there's other ways to do it. For instance, you could have the voting members elect president and secretary, and those just be specific seats on the board. I will say this gets interesting when you have to lace the service of board of trustees terms vis-a-vis your officer terms, because you may have a term of officer that may not necessarily overlap with the same term that you have as a board member. Remember, continuous terms of 3 years. So that's just something to consider, is making sure those two concepts play nice. I like to say that officers, because again, you're a fiduciary. Like being a director is one thing, but being an officer is another thing. And signing up for 3 years to be a trustee, and then also signing up for 3 years to be a president of an organization can be a lot of work. So I recommend a smaller time, because being a president of an organization can be taxing. Yeah.
Based on your knowledge of the different things, functions of religious organizations, what are the recommended officer positions that we have?
Officer positions are fascinating to me, because I sometimes struggle with, besides the ones that are required, what are necessary. Because really all an officer position is you designating one person to do a job. And there is the board can do that infinity, right? And also, very important note about the board of trustees, you cannot have financial documents and say, oh, well, I was just a trustee member. The treasurer was supposed to do those. I didn't look at them. You cannot do that, right? So whether having a treasurer, having someone identified to carry...
Minimum.
I would say traditionally the only ones that I really see is having a treasurer, just because it is good to make sure someone is leading the charge there, but not required, and then president and secretary. Anything else is open to interpretation.
What about having clergy as officers?
So this is my thing about clergy as officers, and I want to separate it. My recommendation is permissible, but it's very difficult to be permissible. No one who is an employee of the church should be on the board. Period. I think no one who is an employee of the church or the synagogue or whatever religious organization should be on the board. I strongly recommend it. I recommend against it. It is a massive problem. It will cause you undue headache, and functionally it's not a good idea, because that person is not able to do their job because of when this person has to, in furtherance of its duty of loyalty, not vote on something, because that is a line drawing problem that is difficult to draw. Because, for instance, let's say you're from a church and the biggest line item is how much you pay your minister. Mm-hmm. And that's very common, right?
That's not hypothetical, that's real.
That's real. No, it's very real, right? Every financial decision that organization makes, every single last one, is now colored by the fact of 60% of your budget is the minister's salary. You want to do this program with the money of the church. Part of that is informed by how much money you have available to do the program because of the pastor's salary. Rightly or wrongly, we live in a world where that's a real thing and distortions happen, distortions of decisions, and that the amount of money you pay the pastor affects how much money you have to do your programs. And that is a reality, but that is why it's probably not a good idea to have someone who is an employee on the board. Because functionally, it's difficult for them to serve. I will say very often what ends up happening is they are ex officio non-voting members. In that way. And that happens with a lot of executive directors. And that's sort of what you heard in the Attorney General's meeting is really pastors are, they're executive directors in the same way that not-for-profits have executive directors. And even though they're not an officer or member of the Board of Trustees, remember a lot of the regulations when they do that recitation say trustees, directors, officers, or key persons. And a pastor is considered a key person. And if not a pastor, whatever the appropriate term for the religious leader of the community is, that's a key person for the organization.
So that means we must exclude and check out the pastor then, or for the church council meeting.
I would say that there are times where the pastor should recuse himself, and that's a discussion between the board and the pastor. I will say there's also specific rules about how, and this is different from denomination to denomination, but there's actually statutes on it about who can set the pastor's salary. I will say that it's typically the members is my interpretation of the regulation. We can discuss about who actually is responsible for that. And there's some disagreement about that topic because the religious corporations law, as I noted, is poorly drafted. But the members should be approving the pastor's salary, which also is something that that pastors sometimes don't like. But yeah, that's officers. So as far as the annual review aspect of this, make sure that you have officers that work for your corporation. So that's checking what you have, what you want, and what's written in the documents. Okay, committees of the board. Basically, in New York, you're allowed to delegate the authority of the board to a group of other people. Now, the requirement is that at least 3 members of the board be on that committee. That gives it the authority of the board. And that's sort of the situation that happens, right? So you delegate 3 people. Any committee that doesn't have those 3 people is just advisory. It's just advisory. So basically, you're allowed to create any committees as much as you want. You can be like, hey, committee, explore this problem. But if you want them to be able to make decisions and bind the corporation, which is the legal term committee of the board, they have to have 3 people that are members of the board of trustees. Fiduciary duty provisions we actually already covered. That's the fact that you may want to put some understanding of the mandatory indemnity requirements in New York. This is true as of law, so whether or not they're in your bylaws, you should make sure that people are aware of them. It's one of the reasons why it's good to put them in your bylaws so everyone understands what those mandatory obligations are. Again, I would consult with an attorney about that. And then conflicts of interest and whistleblower policy, you heard that from the Attorney General that is required for organizations that are not-for-profits or religious corporations in the state of New York to have. You need to make sure that there's a requirement to have that policy and that either in the policy or in the bylaws that annual disclosure is required. Now, when I say annual disclosure, what I mean is you annually, as a member of the board, officer, key person, and relatives to those people. It's a very broad definition. For instance, great-grandchildren are a relative under a conflict of interest policy in the state of New York. You have to make sure you're doing that annually when you get elected and anytime a conflict arises. So for instance, you get put on a board in the middle of your term, you should immediately report that to the board that you've been put on a board of another not-for-profit. And then the duty of care, the duty of loyalty and obedience. You heard it from the Attorney General. I went through them again very briefly as concepts. Remember, the duty of care is, are you taking care to review the documents of the organization and treating this organization as the reasonable and prudent person would? Duty of loyalty, are you being loyal to the assets of the corporation and the corporation itself? And the duty of obedience, are you working in accordance with the organization's mission and in accordance with the laws and regulations thereof? Yeah.
What is the penalty? Because this happened in New Jersey, I don't know if y'all know, but the school district has to lay off a bunch of teachers, board members got onto the board, because there was an issue with me as well with it, but he started functioning on the board and didn't have training before he started signing off and voting on things. What is the penalty for a school district for not ensuring that they have people functioning and voting without the proper training, and also, not reporting things to the state?
So school districts are a little bit different because they're under the Education Corporations Law, as well as their instrumentalities of the state themselves usually. So,
But it's still a board.
but it's not a board of a not-for-profit or a religious corporation. It is a board of a different sort of organization. So
I think the ethics of it is still.
I would say that's probably, the ethics are very similar. For instance, that for boards of business corporations, they also have the duty of care and the duty of loyalty. However, as far as the penalty, I don't really work with government instrumentalities in school boards in that way, so I'm not familiar with that.
What about nonprofit?
So for not-for-profit, it's exactly what his question was, is that depends on, one, what you actually did, right? And also the damages of the corporations. The Attorney General has a lot of power here. And the Attorney General has a lot of power here. And so a lot of the time, the penalty is what did they come up with, right? And what did they come up with and successfully argue? But they have the ability, I will say, if you enter into a related party transaction where the statute is they have the ability to claw back with a multiplier any money that you got from sort of from the corrupt transaction. I do not know. Amendment, be careful. You should be aware of who can amend. I will say that I was told that I should transition. So we are about to start dissolutions in this room. Across the hall is space use and sharing your space. So please grab yourself some additional refreshment if you can during the quick break. But remember, you can't bring it into the chapel. Thank you all so much. It was a pleasure. If you have questions, come see me.